Assalamualaikum warahmatullahi wabarakatuh. Today we are going to start with the new topic for our asynchronous session, which is via Zoom recorded lecture. The topic is Promissory Estoppel. This is a standalone topic, but actually it has some connection with the earlier topic, which is consideration. Let's have a look at the slides that I have prepared. Okay, let's go to the introduction. Okay, what is all about? So basically, this promissory estoppel, it is actually a doctrine. So what's the meaning of the word doctrine? Doctrine, it refers to certain. I provide the definition there. Okay, it means a code of belief, okay, a body of teachings, or even principles or rules of law, basically. So this is the rule of law doctrine, which prevents somebody, a party, from what? From acting in a certain way because the first party, promisor, promised not to do it. Okay, and the second party, promisee, rely on that promise and he acted upon it. So basically, this doctrine is important, is significant because why? It provides a means, it provides a method of making a promise binding. Whatever promise by the promisor would be binding in certain situations, certain circumstances, even though there's no consideration, in the absence of consideration. So in that particular, in this sense, it relates to the earlier discussion of consideration. So normally, in order for a contract to be valid, for a promise to be valid, it must have consideration move from both of the parties, exchange of the things between them. But for promissory estoppel to be applicable, usually it doesn't have, it lacks of consideration, it lacks of elements of consideration. So that's the introduction. Let's have a look at the further explanation or elaboration here. So what is promissory estoppel? Actually, as far as the word estoppel is concerned, okay, we have another types. Okay, we have altogether three. Okay, it's either promissory estoppel. We also have a proprietary estoppel as well as equitable estoppel. But for the purpose of our syllabus, of course, outline, we are going to only cover or focus on promissory estoppel. Estoppel, which is based on promise. Estoppel means you are being stopped. Okay, you are being prevented. You cannot really do whatever you want to do. You cannot sue. Okay, your legal right is stopped. Okay, estoppel from the word estop. So as far as promissory estoppel is concerned, it is a type of estoppel, okay, which has been employed, which has been applied to obviate or to prevent, okay, necessity of consideration. Meaning that here we don't have to prove elements of consideration. So in this situation, okay, to make a subsequent promise made by one of the parties without consideration enforceable against the promisor. Meaning that here, even though there's no consideration from promisee towards promisor, still the promise by the promisor is enforceable against him. He is being estopped from saying, oh, there's no consideration move. Okay, so in cases where what are the situations? In cases where parties are already bound contractually, usually they have contract already between them. Okay, and one of them promises to waive or to modify, to suspend or hold in abeyance, okay, it's strict legal rights under such contract. So in that situation, okay, the promisor, by virtue of his promise, he is being estopped. He's not allowed to go back on that promise. Because why? It will be unfair or unjust to do so. Because if he promised certain things, he promised to waive certain of his right, okay, and later he said, oh no, I'm taking back my words. No, it will be unfair or unjust to the other party, to the promisee. So let's have a look at the origin, okay, why we have the case, which actually established this particular rule or principle. So it was developed by the famous Lord Denning in the case of Central London Property Trust Limited and High Tree's House, or a nickname for this case is High Tree case actually, okay, decision by High Court. So this case is important, significant, because it has established, okay, properly the doctrine of promissory estoppel at common law. Let's have a look at the facts of the case. It happened prior to World War I. Okay, so in 1937, High Tree's House Limited, a company, they lease a block of flat for this rate, okay, 2,500 a year annually from Central London Property Trust Limited. And because of the war and the resultant of heavy bombing of London, so occupancy rates were drastically lower than normal. Not many people, rented the property or occupied the property. Okay, so it was lower. Okay, it fell down. Okay, but 3 years after, okay, in January 1940, to improve to ameliorate the situation, okay, High Tree House Limited made an agreement. So that means they have already tenancy lease agreement between them. But now they have made another agreement with Central London's Property Trust Limited in writing. So they agreed to the rent to be reduced by half. Okay. But however, actually, in their agreement, they agreed, okay, for the reduction of rental here. Neither of them, okay, neither party stipulated, make it clear, right, the period for which this reduced rental was to apply, for how long. Okay, so over the next 5 years, High Trees, the lessee, okay, lessor is the one who leases out. So the lessee, High Trees, paid the reduced rate, just pay half discount, okay, discounted price, reduced rate, while later, okay, after 5 years, the flats, okay, began to fill, and by 1945 the flats were full again, okay, because during the war only half of the flats were occupied. So because of this, in light of this, the lessor, Central London, sued for payment, okay, of the full rental cost, and they are suing from the period of 1940. They say, okay, please pay us the full rent, okay, from 1940, because now you managed to get your flats full again. So when the court, when Lord Denning was delivering his judgment, so this is what he decided. Okay, so based on his design of the doctrine of promissory estoppel, Lord Denning held that the full rent, okay, was payable, okay, was due from the time the flats became fully occupied. When was it? In early 1945, not earlier. Okay. And then Central London, the one who agreed to waive the full rent, okay, to give the reduction in rental here, Central London could not go back on their promise of reduced rent for the period of the war, because High Trees reliance on the lower rate. They agreed, okay, for the lower rate. So and then High Trees, the lessee, rely on the the discounted rate, okay, given by the lessor, by Central London. And actually, if you were to trace some other earlier cases, we have actually, before the case, High Tree case, the 19th century case, we have the case of Hughes and Metropolitan Railway. So in this case, it is between landlord and tenant. So landlord gave his tenant 6 months, okay, notice to repair, and the event of failure to repair, the lease would be forfeited. So that's the content of the notice. And then within the 6 months, actually, landlord also opened negotiation. They started to negotiate with the tenant to sell off the lease, okay, to sell off the property. And then because of the negotiation, okay, because they have started to negotiate, so tenant stopped, okay, whatever repairing work. They didn't do any repairing work, okay. And then shortly after, actually, negotiation broke down, it failed. And at the end of the 6 months notice period, landlord claimed to forfeit the lease. And House of Lords held that, okay, for whatever arrangement, promises between them here, landlord could not do so. Because why? Landlord had, by his conduct, okay, the way he communicated, the way he reacted, okay, led the tenant to believe that the landlord will not enforce forfeiture, okay, at the end of the notice period. And because of that, the tenant rely on this, okay. That's why the tenant stopped, okay, from carrying out repairs. But again, the 6 month period, the notice period for the forfeiture would begin to run again from where? From the date of the breakdown of negotiations. Meaning that here, it was waived, it was being stopped for a certain time, but later it started to run again. Okay. Now we want to know, okay, from the cases just now, okay, from the introduction, from the elaboration of the doctrine, now the specific issue, the specific question is that, okay, how does the doctrine operate? How it is being made applicable here? So the doctrine operates, it will be relevant, it will be it will be operative where there has been a representation by one party. By whom? By the promisor, that he or she does not intend to enforce his or her strict legal rights. And then it was made with the intention that the other party, the promisee, would rely on the representation. Okay, and the other party, the promisee, actually, yes, rely on the representation. And on the part of the promisee, okay, there's no consideration from the promisee towards the promisor. So, what is the effect in that particular situation? Okay, the party making the representation, okay, will be stopped, okay, from enforcing his or her strict legal rights. Insofar as it is inequitable to do so, unfair, okay, to to enforce his strict legal, because he promised not to, and the other party relies on the promise, even though there's no consideration, okay, provided by the promisee towards the promisor. We go to the features. We have actually all together for the purpose of the discussion. Okay, we have broken it into 6 altogether. Okay, the first one is mere silence can give rise to a promise or active encouragement. And then a representation or promise or encouragement must be clear and unequivocal. The third one, it may be applied in the case where there is no, okay, even there was no pre-existing legal or contractual relationship between the parties. Normally there must be, but sometimes no need to prove, okay, whatever existing contractual relationship between the parties. And then another feature is that Promises Act has influenced the promisee. And number 5, representation made by the promisor may be of facts or of law. And then the last one, it is unjust or to insist on strict legal rights, okay, on the part of the promisor, where when the promise is not kept. Okay, in even the promise is not kept. We go to the first one. Mere silence can give rise to promise or even active encouragement. We have the case of local case, Boston Trading Sdn Bhd and Arab Malaysian Merchant Bank Sdn Bhd. It involved a company and also a bank. And this is an appeal actually. Okay, this was an appeal because trial judge gives certain ruling, but now the appellant appeal against the decision. Okay, it involves certain terms of factoring agreement. Okay, I give the definition of factoring agreement after this. So it was entered between respondent and another company, one Chemitrade, the appellant. Okay, appellant was Chemitrade. The factoring agreement was entered between two parties, okay, respondent and Chemitrade. And appellant here was liable to pay respondent this amount, very big amount, 203,000, okay, 72.56 cents. Okay, factoring agreement is actually a specific agreement, a financial contract that sets out, it has certain arrangement, okay, the cost and terms on which a factoring company agrees to purchase a business outstanding invoices. There will be some other company who step in, okay, take over the invoices and to pay whatever outstanding or the debt which is overdue. Okay, let's go to the facts here. Chemitrade, okay, the company, it was selling goods on credit, okay, to the appellant. I mean that here, Chemitrade is the creditor, appellant is the debtor. And then the credit terms had strained Chemitrade cash flow because they need money, okay, but they sold the goods on credit, okay, not on cash term. And to alleviate the problem, to improve, okay, the problem here, to overcome the problem, Chemitrade actually entered into factoring agreement with the respondent. So it will be respondent who will be pay off the whatever amount due, okay, to Chemitrade. So by the agreement, respondent would purchase Chemitrade's invoices, okay, in respect of the goods at discount, and then the respondent would claim full value from the appellant, okay, at the end of the credit period. So that's basically the arrangement between them, because now Chemitrade needs cash flow. That's why the company entered into this arrangement. And then because of the agreement arrangement here, okay, respondents started to purchase the invoices from Chemitrade. And then what they did is that, okay, they forwarded the appellant the payment. So they took the invoices, okay, whatever amount due, and then they paid, okay, they forward the payment, okay, to the appellant. And each of these invoices, okay, respondent had endorsed the statement. So there was endorsement here. specific wording used here. Okay, any objection to this bill or its term must be reported within 14 days after its receipt. And appellant, okay, when they receive, okay, the invoices whatsoever here, they had not complained about any of the invoices, okay, and actually for certain period of time, for 7 months, okay, they just continue to honor the endorsed invoices. They receive and then they just honor, okay, they cash it out basically. And then later, okay, appellant after 7 months, okay, appellant, however, refused to pay on about 20 of the invoices, okay, and then they submitted, they subsequently challenged the validity, okay, of the invoices. But it happened only after 7 months of just accepting, okay, honoring the invoices. So now when the case was brought to the federal court here, the main issue which is relevant for our discussion is that whether, okay, in the circumstances, estoppel would apply, okay, to bar, okay, to stop, to prevent appellant from challenging the validity of the invoices or the endorsement in question, because they have been honoring, accepting the invoices for 7 months. Later only they challenge, okay, the invoices. So now can we raise estoppel? Is estoppel applicable in this particular situation? Okay. And the court held that, okay, this is the actual wording. Okay, sorry for it's too wordy, but maybe we focus on certain words here. So it is stated, the federal court judge, okay, the court make it clear, okay, made it clear that doctrine of estoppel is a flexible principle, okay, by which justice is done according to the circumstances. It is very flexi, okay, and the purpose is to uphold the justice here. And then it is a doctrine of a wide utility. Okay, you can read in between. And then the last part here, estoppel, okay, the usage is that, okay, may assist a plaintiff in enforcing a cause of action. So how does it work? By preventing a defendant from denying the existence of some fact, okay, which would destroy the cause of action. Okay, we stop here. We are going to continue afterwards. I stop share for a while.